and welcome to the Pinellas County Board of Adjustments and Appeals. We have received your cases and have studied them, and in some cases visited the site. Please understand that we don't bring these cases. We are citizens tasked with weighing the evidence submitted in order to make the most informed decision possible. We have no personal interest or stake in these cases except for the overall good of the community. The staff has made a recommendation on each case, and that recommendation is input only and may not necessarily be the opinion of this board. If you are planning to speak for or against any application, you must be sworn in prior to testifying. If you have not been sworn in, please do so now with the clerk here at the right table. This is how we will proceed. When your case is called by staff, the applicant should come right to the podium and give us your name and your address. The applicant will then present their case, including comments from supporters and attendants. Comments by supporters should be new information, not just an expression of support. The applicant may display the volume of support by a show of hands. Speakers will have 3 minutes. Opponents will then be given an opportunity to state their objection. If there are numerous opponents, it is preferable for them to select 1 or 2 spokespersons. Speakers will again have 3 minutes. Subsequent objectors should add new information, not just rehash prior stated objections. Opponents also may display the volume of objectors by a show of hands. This will be the only opportunity for opponents to state their side. The applicant will then return solely to rebut the comments of any occupants and may not bring any new information or testimony at that time. Finally, we will close the public hearing and the board will discuss the case, make a motion, and vote. With that, Mr. Bailey, please call the first case.
I'm sorry, Mr. Chair, I need to read that.
I'm sorry.
Quasi-judicial statement.
Yes, like a little more information.
The matters heard by the Board of Adjustment and Appeals are quasi-judicial in nature. Please note that only competent, substantial, fact-based testimony or evidence may be considered by the board in deciding the matters before it. Pure speculation or opinion, not based on competent facts, cannot be legally considered by the board. Lay testimony with fact-based support, including but not limited to meeting minutes, surveys, engineering reports, etc., may be considered competent substantial evidence.
Thank you. Mr. Bailey.
Thank you, Mr. Chair. The first case on the agenda is case number VAR 2310. This is Michael Bartoletti. The request is a variance to allow for construction of a 6-foot-high masonry wall with columns along the south property line where 4 feet is the maximum height allowed within the required front setback, and a 5-foot-2-inch high chain link rolling gate where 3 feet is the maximum allowed within the required front setback for the property located at 2219 Tampa Road in Palm Harbor. Recommendation is conditional approval. Tampa Road is a 4-lane divided county arterial road. And over the past decade or so, other wall and fence height variances have been granted on similarly situated parcels in the general area, including the adjacent property to the west. There are also subdivisions within the area with a 6-foot-high perimeter walls, so this is not, this request is not out of character with the general area.
Thank you. Is the applicant here? Please come forward. When your case is called, please start on up to the podium. While he's here, is there anyone here wishing to speak in objection to this application? Thank you. Name and address, please.
My name is Michael Bartoletti.
Kind of stand right in the middle, please.
Oh, sorry. My name is Michael Bartoletti, and my address is 2219 Tampa Road, Palm Harbor, 34683.
Is there anyone online for this subject?
No, there is no one online for this case.
None? Thank you.
Seeing no objections, I'm going to move for staff recommendation of conditional approval in accordance with the findings of fact as outlined in the staff recommendation.
Excuse me, Mr. Chair.
Alan,
I'm sorry.
So we do have an online member in
Online,
attendance.
he has his hand raised.
Yeah, we know that.
Oh, okay.
Swearing.
Allow him to participate virtually.
John?
To swear him in, we have to do, I haven't been through that procedure, so.
I can't hear you. You have to
I'm
come
sorry, I
up.
thought he was gonna provide some input to the case.
John, did you want to speak to this case?
I just wanted to find out if you need another motion to allow me to vote today.
All right, so, I see what he means, okay. Yeah, so because we have a member virtually attending, we have to go through a perfunctory motion to allow him to, so we can leave the motion on the table, let's Have a motion to allow him to participate.
Can I get a motion to allow John to participate? I was thinking about it. Good.
No, maybe.
So moved.
Second.
Motion, all in favor?
Aye.
Unanimous. Back, we have a motion and a second on this first case. All in favor?
That I need to.
I don't have a second.
I second.
She second.
I second.
I mean, for the case.
For the case.
Yes, for the case also.
Okay, thank you.
Jesus. All in favor?
Aye.
Aye.
Opposed? Unanimous. Thank you.
Thank you, appreciate them.
Next is case number TY2-2311, Celicia Foley, Green Acres Child Care. It's a modification of a previously approved type 2 use to allow daycare in RR zone for the property located at 9110 102nd Avenue in unincorporated Seminole. Recommendations, conditional approval. You'll probably remember this from the not-too-distant past. It's a modification of a previous approval that you granted back in July, so a couple months ago. The original request included proposed construction on a new 3,500 square foot attached addition for a daycare. Proposed modification to the daycare would make the addition parking lot and playground areas more internal to the site, so they're moving things around. A type 2 use is required again because it's a major modification to the location of these structures, but they're more internal to the site. And there are no changes in the number of children attending daycare nor an increase in the building footprint. It's still the 3,500 square foot. It's just in a different portion of the property. So therefore, we recommend conditional approval. And then the applicant is on Zoom online. So she may need to be sworn in.
Is there anyone here wishing to speak in objection to this application? Okay, show me the applicant, I guess.
There she is.
Can you give your name and address, please?
Alicia Foley, 9110 102nd Avenue North, Largo 33777.
Ms. Foley, can you please raise your right hand? Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay.
Are there any objectors online?
Nope. I've got the list.
Hearing no objection, I'm going to move for staff recommendation of conditional approval in accordance with the findings of fact as outlined in the report.
Second.
I have a motion, I have a second. All in favor?
Aye.
Opposed? Unanimous. Thank you. Next case, Mr. Bailey.
Thank you.
Next is case number VAR 2314, Speckled Trout Boatyard Incorporated. Requested a variance to allow construction of a bed and breakfast having 6.9-foot front setback from the eastern property line where 10 feet is required and a 10.7-foot side setback from the northern property line where 20 feet is required for the CR zone property located at 370 Bayshore Drive in Ozona.
I have requested it, yeah.
Recommendation is conditional approval. So the subject property contains a speckled trout marina that's bisected by Bayshore Drive. And the portion of the property on the west side of Bayshore Drive contains a small upland area with boat ramp decking, small bait house, several pillars that were put in place years ago to support a planned duplex that was never completed. A planned duplex received a variance in 2005 under the property's former R4 residential zoning designation that allowed a 5-foot front setback. Since that time, however, the zoning was changed to commercial recreation, and the previous variance approval expired. So the CR zoning does not allow residential uses like a duplex. You can't live there permanently, permanent residential uses, or short-term vacation rentals. But it does allow a bed and breakfast as a permitted use. So this is a request for a variance of the location of the bed and breakfast, not the use itself. The use is a permitted use.
So just move it to some different location.
It's not existing now, but it's basically want to put it closer to the front property line than normally allowed, and also closer to the north side property line than normally allowed in the CR district. The setback variances for proposed bed and breakfast are being requested due to the small size, irregular shape, and shallowness of the upland area on the portion of the subject property on the west side of Bayshore Drive. The proposed location is very similar to that of the formerly approved duplex that you approved in 2005. The existing pillars will be removed. New ones constructed to support the proposed two-unit, two-story bed and breakfast. So it'll be a two-unit bed and breakfast. But again, that's allowed permitted use. It just has to go through the permitting process, site plan review, things like that. So this is just for the variance, for the setbacks. And importantly, the rezoning of subject property to commercial recreation in 2014 also included a development agreement that set various development restrictions on the overall property. So this property has a larger component on the east side of Bayshore Drive. But that development agreement had development restrictions on the overall property, so it would not be allowed on that side of the street. It would only be allowed on the west side based on the deed restrictions tied to that development agreement. And also of note, the residential property adjacent to the north received a similar setback variance relief in 2014.
Okay.
So,
Yeah.
so the duplex could have been built years ago,
Yes.
and, okay.
Is the
It used to
applicant
be
here?
a residential zoning district that would allow a duplex by right.
One more question, Mr. Bailey. If the duplex would have been built, could they have converted the duplex that would have been there to a bed and breakfast now with no problems?
It wouldn't have been, had to come back through setback variances, no. It would have, the use would be allowed now, so no, it would not. It would be fine.
Be fine, okay. Thank you.
You're on.
You're on.
Good morning. Jamie Mayer of the law firm Hillward Henderson, representing the applicant, 600 Cleveland Street, Suite 800 in Clearwater, and I have been sworn. Thank you, Mr. Bailey, for the excellent presentation and for the staff report. I have a PowerPoint presentation, which I believe is loaded. I don't know if that's up yet for you all to see. Is that- There we go. Thank you so much. So as Mr. Bailey explained, the board is likely familiar with this site as the Speckled Trout Marina, which is subject to a significant number of deed restrictions that bind the site in perpetuity, which was part of an agreed upon set of conditions in connection with a rezoning of the property back in 2014. It was initiated in 2013, but recorded in 2014. This is the only properly zoned marina in Ozona and the county at large. This has the commercial recreation zoning that is appropriate for a marina. It has the commercial recreation future land use as well. And as was explained, so this was a duplex structure that was approved as to variance and building permit back in 2005. And it wasn't constructed, but that was when the property was zoned residential. And so lesser setbacks applied, but it still needed a variance because as you'll see, the property is very irregular and difficult to build on in terms of meeting all the setbacks. So the property was rezoned to commercial recreation, greater setbacks apply, and it's now proposed to be used as a bed and breakfast, which is an appropriate use in commercial recreation because that contemplates primary uses such as marinas with accessory transient accommodation uses. I'll show you an image of the larger overall site so you can see where this is in relation to everything else. But this is the proposed site plan. I know it's a little difficult to see with it superimposed, but the red hatched area is the proposed footprint. And as you can see, Bayshore Drive actually cuts down, not the middle, but cuts down part of this property. And so the boundary line here is to Bayshore Drive and to the seawall. So this is sandwiched between water and a right-of-way that splits the property. And so the proposed setbacks are a 6.9-foot setback to the Bayshore Drive boundary line, which is actually greater than what the previous duplex structure received in 2005. So it's actually going to be angled more parallel with the right-of-way, which when we discussed with staff at DRC, that was a preferable design. This is going to be a skinnier structure, as you can see, compared to the originally approved duplex. It's a little longer to the north. If this had been the footprint, though, that was proposed originally back in 2005, they wouldn't have needed a variance for the north portion. They only need that because of the commercial recreation zoning that they voluntarily rezoned to. The goal, ultimately, is to incorporate on-site lodging like many other marinas have in the county. Some have 1 or 2 units, some are full-blown resort marinas. This is something that allows marina owners to diversify. When it's harder and harder to operate, it's more and more expensive to operate as a marina, and the comprehensive plan recognizes that and incentivizes, encourages preservation of existing marinas. It is more and more expensive to operate because there's so much pressure to convert these into private residential waterfront. And so Speckled Trout, which has the proper commercial recreation future land use, proposes to implement this like many other non-conforming marinas do. I am aware that you all have received correspondence from Ovis. I'm sure you're going to hear from them today. Candidly, we are surprised at the opposition because this duplex structure was discussed at the time of the rezoning, was discussed in the very conditions that bind the site. The applicant gave up a lot of rights based on the conditions that were recorded. And so one of the rights he did not give up which is the right to construct a duplex structure in this particular portion of the site. He can't do it anywhere else. And so it's surprising to us that that's being discussed again when it was already vetted, it was discussed, and it was deemed appropriate. As I mentioned, I wanted to show you the site as a whole. Take a look at parcels 1, 2, and 3. Those aren't actually parcels, but they were part of the conditions that say, well, you can only do this in parcel 1, you can only do this in parcel 2, you can only do this in parcel 3. Parcel 3 is skinny, it's strange, but it is the only area on the site where a duplex structure is permitted. Also, a duplex structure is one of the only structures that is permitted on parcel 3. So he can't really do much else on that parcel. That is one of the bargained for rights and restrictions that bind this property. Although, as described, these pillars will be removed, I thought this was a great visual representation of where the original footprint was, and very similar to most degrees where the structure will go. You can see, as Mr. Bailey mentioned, the property owner to the north has a significantly reduced smaller setback as well due to a similar situation and a similar practical difficulty. And then you can also see the pillars in relation to the right-of-way. As I mentioned, this will actually be, they'll be a little bit farther away from the right-of-way and they'll be running more parallel with it, but this is again the general idea. And another angle, I will note that to the south, there is an open area where they have the boat launch and they have a little gravel area which abuts the waterfront where many people like to gather to watch the sunset, and that will not be affected by this request because it is being shifted to the north. It's not going into that area where people like to gather.
Jamie, can you go back one slide?
Yes.
Looking at the slide on the right, the pillars, will the proposed building be closer to the roadway than those pillars are?
No, it actually will be, let's see, I can go back to the site plan.
Okay.
If that's helpful. Yeah, actually, I just wanted to make sure I was correct when I said this. It'll actually be where you were looking, it'll be farther. So you can see that red hatch area and those pillars. It's actually going to be a little farther from the right of way.
And Jamie,
Yes.
across the street, across Bay Shore, is that there's to the parking? There's parking there? That's
Yes.
gravel?
That's correct. Yeah,
So
that's,
that would be where, if somebody was visiting there by car, they would park there, or?
I believe so, and I can have the applicant speak to that. There is a huge portion of parking. There's vehicle parking, and then, of course, in the back, there's boat parking.
parking, okay.
But there is also some parking spaces on this side of the driveway, or of Bayshore Drive. So I can, and actually, there will be parking underneath the structure itself.
Oh,
So because it's
okay.
going to be on pillars, I'm sorry, that's actually the answer.
Yeah.
There will be parking under the structure for the
Okay.
people who would stay there.
I didn't think of that.
But yes, there is a lot of parking
Okay.
elsewhere. But I will run you through the variance conditions briefly. I know you all are, or the criteria, I know you all are very familiar with them, but of course, you know, it's something we need to discuss. There are, I think, self-evident special conditions that affect this site. It is highly irregular, it is narrow, it is the only part of the property that he has the right to construct a structure that is going to be used for the transient accommodation use that is a permitted use by right. And a practical difficulty exists because of that. He cannot use parcel 3 without a variance. He had a variance approved previously because he couldn't use it without a variance. A similarly situated property to the north had to have variances too for a very similar reason. It's a strange place to be between the seawall and Bayshore Drive here. And so this is the minimum deviation necessary to make reasonable use in the way that he bargained for and is perpetually restricted. It's not self-imposed. He didn't create, just like the neighbor to the north didn't create, the waterfront and the right-of-way. And he also, again, previously had a variance approved for this. The setbacks are different now. And also the use is different because it's a transient accommodation use, whereas previously it could have been a regular duplex. This is in harmony with the code. It's permitted in the zoning. It's contemplated expressly in the approvals that bind this site. It's consistent with the comprehensive plan, as I've said a few times. This is commercial recreation, future land use. Transient accommodations are contemplated. Actually, they're contemplated at 10 units per acre, which is a lot, but that's certainly not permitted here, or not what's proposed. But it's a marina with transient accommodations, which is exactly what that category envisions. A rezoning wouldn't be helpful. It's properly zoned and it needed setback variance before, it needs setback variances now. and it's not going to be injurious to the area. Again, these conditions were discussed at length. They were in large part crafted, or it was a discussion with the very people who I believe will be speaking to you and opposing you again. These conditions were for the express purpose of safeguarding the area. A duplex structure was considered to be appropriate, compatible, consistent. Where we are proposing it, we're just talking about where it's going to be now. And so accordingly, it doesn't circumvent any conditions. In fact, it implements one of the conditions. In some, Speckled Trout Marina is one of the few remaining marinas in the county. It's the only one that's properly zoned. It's not a non-conforming marina. The applicant gave up a lot of rights, but this is not one that he gave up. He just needs a variance because the prior variance expired to implement what he's proposing now. And we respectfully request your approval, and I'm here for any other questions. Thank you.
My question is why didn't the duplex get built?
I think that's something the applicant can speak more to. However, it was approved back in, so the building permit was approved in 2007. Wasn't a great time for, so he focused his resources on expanding and enhancing the marina, underwent the rezoning. That took a long time. And now, I mean, we were before you last year to increase the number of wet slips, and it's actually taken, if we went back, it's taken 6 years and they still haven't gotten all the permits for that. It is a slow-moving process. Sure. It's partly money-driven, and he's able to build this now.
So was the duplex significantly smaller, or was it the same size as what's being proposed or contemplated?
So I don't have the exact measurements because that wasn't included in the conditions of approval. Visually, I could go back to it. I think it's similar, and it would have been 2 stories. So I don't have that exact measurement, but
okay.
I think it's
Just for the
similar.
board's information, the permit for the duplex was first issued in 2006 and was later rescinded at the request of the property owner in 2016. So there's no permits for a duplex active at this time.
And just to clarify on that, the applicant actually extended the permit as many times as he could through the rezoning. I have a paper trail of the times he asked to extend it, and he was told he couldn't extend it any longer. So he did agree that and understood that it had to be withdrawn. So I wouldn't quite say that he demanded it be withdrawn. He did try to extend it for years, but you can only extend it so many times.
The yellow building that was shown in the picture, I believe, is the bait house,
Yes,
and that's going to go away?
yes.
And are you going to come back here someday looking to build a bait house again?
I'll be honest with you, I don't think we can. So that's my opinion. On the concept plan, parcel 3, and in the conditions, it says you're allowed to have the duplex structure, you're allowed to have the existing 300 square foot bait house. It's shown on the concept plan, so I don't see how you can have both of those things. And I'm sure that would be something that the county would have to opine on, but that's how I would read that.
Okay.
Based on those pillars, was the bait house just going to stay under the duplex?
I think I'd have to ask the applicant that. I doubt it because the parking needs to go under there, but if they could accommodate both, then perhaps.
Okay.
We could have him come up after.
Sure, let's have him come up.
Is there anyone else here wishing to speak in support of this application?
Let's hear from the owner.
Let's hear from the owner. And then we'll open up.
Assuming he's speaking in support.
Hi, thank you for your time today.
Name
My
and
name
address,
is Tom
please.
Bennett, or Rick Bennett, I go by. Didn't have a choice in that. I'm at 343 Bayshore Drive, which is the property across the street from the bait house. And it's in Palm Harbor, Ozona, 34683. Any other information? The bait house will have to go. You cannot build a code on anything over something that's not the code. So the permit will require that be torn down along with all the pillars. The pillars, there's been 3 height changes since they were constructed, and they would be very difficult to get an engineer to seal the integrity of those pillars, having sat there like Stonehenge for so many years. So we'll be putting in new engineered pillars to support the new structure. The bait house is really in harm's way. We were so lucky during this last hurricane that we didn't lose coolers and freezers and whatnot. We're going to relocate the bait house on a parcel that we own that's 10 feet above sea level instead of at sea level, or 2-3 feet. And so it will be destroyed as part of requirements and then reestablished closer to the boatyard. We sell beverages, non-alcoholic beverages, ice, and frozen bait. We also sell shrimp, but that'll stay down by the water because we have to have a circulating system for that. The structure is very similar in size, I believe, and I haven't done the calculations, but the existing pillars were 40 by 60, 2,400 square feet. This is a little longer but narrower, so it's very similar in size to the existing or the priorly approved setback variances and the duplex itself.
Do you have entitlement for the location where you're going to put the bait house, or are we going to need to see you again for that?
I don't know that for sure, but it'll go through the building permit process. And so they'll have to, I guess they'll approve it as part of that. I haven't gotten that far along, just decided it's better there on high ground and closer to the boatyard where our members park or they provision their boats before we go get them with the tractor to put them in through the ramp.
Okay.
If I could just,
You mean,
to that point, I would have to study the conditions more, but there is a provision where there is a shed of a certain height and a certain dimension. It's in the conditions, which are in the packet, but there is a provision to allow a shed on another part of the property. Candidly, I have not, just like Rick, haven't really thought that far ahead. Maybe a bait shop would be allowed there. I don't know, but the duplex structure is more important. It is the primary goal for this site, and again, that's one of two things, and I do believe they're mutually exclusive, that could be permitted on parcel 3.
Okay. Can I return to my seat?
He'll go ahead. I'm going to ask him a question. Could you keep Rick?
oh, hold on, sir.
Yeah, Mr. Bennett?
I'm sorry.
Yeah, and the property across the street also is yours, in the large parking lot, and there's a home there. Is that your home that's right across?
There's two homes there. One is mine, and I'm currently residing in. One was my sister's, who died 2 months ago from a pulmonary fibrosis and untreatable lung disease. And I bought the home from her children because it's a critical part of the marina. She ran the marina for the first 10 years of its operation. Then she wanted to retire, and so I bought her out of the marina. She kept the house. When she passed, the house was in a trust that went to the children, and I bought it from them. So I own both the houses on the upland side.
And those homes are similar in height to what you're proposing to have built?
Well, one home is built on a slab, and the other is built on elevated pillars with blowout walls, the newer one. The older one was built, I'm going to say in the 60s, and it wasn't required. I guess the living floor is about 15 feet above, and I don't know that the ground floor was originally permitted, but it's what it is today.
That was my only question. Thank you.
Okay.
Thank you.
Thank you.
Thank you.
More questions? All right, let's hear That's it for people support. Anybody wishing to speak against this application, please come forward and give us your name and address. And
And Mr. Chair, while we're in between, I noted, maybe tech can change this, but because this video today is now part of the record, this is our first live stream meeting, they've got us as Board of County Commissioners on the label for the video.
We can do a lot more stuff.
I was I know. Yeah, that one I gotta, hopefully they can change it to Board of Adjustment and Appeals with some typing upstairs or behind the wall here.
I'll talk about fluoride.
come on.
Rezone.
Thank you for this opportunity. I'm Robert Bell, a 30-year resident of Ozona.
Need your address, please.
105 Homeport Drive in Palm Harbor, 34683. I do want to mention that there's a few objections that I have personally, one dealing with environmental, further endangering our threatened species. As you know, there's 5 species of turtles and fish, 8 species of coral. There are multiple manatee deaths from boats. This is also going to increase the carbon footprint and pollution of an already fragile ecosystem. The building itself may cause structural weakness to the seawall, road, and erosion. The B&B, as the additional docks, should require some type of federal, state, environmental oversight. These changes, I personally believe, are a hazard to the ecosystem and the community. There's something that has been neglected is the safety. It was mentioned that that corner is a sunset area for most of the community. Many children walking or people on bikes congregate to watch the sunset, the golf carts. At the same time, the tractors are pulling boats across a single-lane road. I personally have witnessed several accidents, whether it be vehicular, bikes, pedestrian, or golf courts. This is a fatality ready to happen. We do not have sidewalks. So for the most part, we walk on the road. So again, this is going to increase that. Also, I do want to mention the bridge on Shore Drive is to be rebuilt, forcing a detour down Lagoon, Ridge, Bay Street, and Bay Shore, further contributing to the traffic congestion and overuse and the safety of the children, pedestrians, and adults in the area. I personally have lived in Ozona for over 30 years. It's a 150-year-old community. I've watched it grow to approximately 775 households. It's a significant strain on the water, sewage, electricity, gas, and garbage. I don't think we can sustain much more. The variance encroaches an additional 54% on Mr. Gagg's property and the view, as did the dock expansion, and the variance of an additional 69% to Bay, going back on Bay Street. These are not insignificant variances. And it leaves little space. We're not looking for a New York state of mind. It obscures the Gulf view from the neighbors such as the Gaggs and the Hunts. This B&B may unwillingly turn the community into an Airbnb, which we do not want. Ozona has at least 7 restaurants, including dining, bars, breweries, and pizza. By definition, this B&B will have to provide breakfast, which expands into another eating establishment, causing more congestion and safety issues. From this 30-year Ozona resident, enough is enough for our small community. As a courtesy to the community, ecosystem, and safety, this variance should not be approved. Thank you very much.
Yes, let me set your mind on one thing. This request is subject to getting all permits. So if there are any environmental issues and the state has to get involved, they'll have to get them. If they don't, they don't. So but again,
I
all
understand
permits,
that.
sewer, water, all those things will have to be part of the permitting process.
I'm a bit of a tree hugger, and I love the golf, and it's getting hurt. That's all
I get
I'm
it.
trying to say.
Yeah, thank you.
Thank you.
Just wanted to let you know that.
Also want to mention that the code limits the food service to overnight guests only.
Yes.
Bed and breakfast. They cannot be open as a restaurant.
Hello, everybody. Hi. My name.
Kind of stand right in the middle there, if you would, please.
Okay, sure.
Thank you.
Last time, this is, before I forget, this is just with the storm coming.
Need an address for you.
Oh, yeah. My name is Stephen Gagg. My address is 380 Bayshore Drive, Palm Harbor, the property north of Speckled Trout. And the spur of the moment with the storm, and I really didn't feel that much of notice. We were hoping to get a little bit postponement because really there would be so much more opposition, but we got 93 in 2 days, 93 signatures of everybody, all in the immediate area. And in general, I don't have much to say, except for when I bought my property, that I heard from everybody, you know, and considering people that, you know, was super close to the situation, that they were able to build strictly above, at best, strictly above the pilings. A lot of times they're saying structure. It's not a structure, it's pilings. And they never did it, and they had the opportunity to. And whatever is fine. I just wish if they do something, is really fine with me. I just don't want 10 foot with strangers and on and off partying like crazy, 10 foot off the property line. Yes, I did get a variance from 7.5 foot to 2.5 foot on the side, and I used 2.5 foot, which I really didn't even need. I just did a little bit of platform, a little bit more. And I also only had to be 10 foot off the road. I was 22 foot off here and 16, probably 23, but 22 and 16. So, and I left it open. It looks like Ozona where I am. It's all, you see it, but all I ask is I just hope that people could think if they were next to a bed and breakfast. I never ever heard of a bed and breakfast. They're going to go in there at any time. And, you know, I just hope that, you know, that I hope that it's 20 foot away and it's not 10 foot away. It would make my life a lot easier, and I just want to live my life, and thank you.
Thank you.
Hope it made sense.
Anybody else wishing to speak against this?
How are you? My name's Kerry Hunt. I'm at 379 Bayshore Drive, also 377 Bayshore Drive, which are the properties across the street from the speckled trout where he's looking to put this in. First off, this is not what the city of Ozona wants. We've talked to several people. Obviously, you can see you've got opposition here that are against it. This little stretch of land is the last open area to the ocean, or to the water at Ozona. And if he builds a structure here, it's going to block a big portion of that. More importantly, my wife and I, we own the two properties there. We worked hard all our life to be able to afford to live in a place like Ozona. It's not cheap to live in Ozona. We've worked hard to be able to afford the properties that we have. And we've done it honestly by hard work. We've never taken anything from anybody, and we've never cost anybody a dime to do it. So with that said, our neighbors, we do care about our neighbors. The last thing I want to do is walk out my front door in the morning and hope I don't see my neighbors because they've done something that's caused us a problem or that we don't like. A few moments ago, the lady showed you a picture of what the pilings looked at showing out over the boats over the water. That's my view. That is the view from my property. That's also the view from the property next door that we own. I was told last time I was here in regards to the boat slips that I wasn't entitled to a view because I live across the street. I respect that. But what I am entitled to is the value, retaining the value of my property. And if you allow him to put this easement or this to change the zoning and to expand that property out to the road, off to the side, you're going to devalue my property. That's going to devalue the property I have. With the storm, with the holidays, I didn't have time to do a full-blown market analysis, but I did speak to several real estate agencies, and every one of them agreed that blocking that view of that property is going to devalue that property. It could devalue it as much as 20% if they do that. Again, if we have a postponement, I have a chance, we'll do a full-blown market analysis, and we'll be able to find out what that might be. But right now, we know that it according to the real estate agents I've spoke to, they have both told me that it would be a detriment to our property if we have it. So.
If I could help you, I just let to our council, the view, market value is not something we can consider. So save yourself.
So you can allow him to change, increase his value and decrease my value.
Well, we're not doing it based on increasing his value, and furthermore, unsubstantiated reports
As I
from
get, as I
realtors.
said moments ago, that if you give me the chance to postpone this, that we will do a full market analysis.
We need what's called substantive evidence.
I understand that.
And that
And I'm
means-
offering that up with
that means
a postponement.
Firsthand expert testimony.
And I'm offering that up with a postponement.
You've had ample time to prepare for this case. This is not something that just came up.
Sir, we had a storm come through that took 2 or 3 days for us to clean up, get ready for and clean up, and then a
Appreciate
holiday
that.
after that, so no, we didn't have ample time. So, and then there's a rumor that I don't know the truth that whether it, but there've been talk about expanding the road.
Which
Bayshore,
road?
and expanding the width of the road Bayshore. I don't know if that's true or not. but I
Expanding
heard-
Bayshore?
I'm sorry?
No idea. Not that I know
I've
of.
heard that they've talked about expanding it, so if you give him the
Again,
right
that's
to the
not
setback.
substantive evidence.
I'm sorry?
Again, that is not substantive evidence. You've heard, she told me, someone said, none of that's admissible here.
I'm not trying to miss anything. What I'm trying to do is to keep somebody from destroying our community, and what we have. So,
Can I ask you a question?
sure.
What did you expect was going to happen with the pilings that are been standing there for the last
Pilings were there
15
when I
years?
moved there, and it was my understanding that they never built on them, and they couldn't the way they were.
And
So
that
I
was
don't
just
know.
going to be a Stonehenge kind of a monument forever?
You know,
They were put there without the intent of building on them?
No, I assumed that at some point they had planned on it, but it was before I moved there.
Yeah, I find it surprising that the neighbors are suddenly astonished that something's going to be built on the pilings that were put there for the intent and purpose of
You know-
building a duplex
All right, I tell you
15
what,
years ago.
it's my understanding that those pilings were put there to build a building on it, so let him build a building the size that the property allows, instead of giving him the variance to allow him to build it bigger.
Okay.
If that's what he wants.
Yeah.
So I can't disagree with that. If the property says he can build that size, then I'm fine with it.
Okay.
But the variance to build it bigger is what we're against.
But if he moved 3 feet back, those pilings would still be there, and it would still be the same obstruction of view, would it not?
No, well, the building would, yes, but it wouldn't be the amount of obstructing the view that it did before, because it wouldn't be, the variance wouldn't be out forward and out to closer to
It's
Mr. Gas.
cross, but, and if there was a duplex there, if they continued with the duplex, you'd have the same impact, correct?
The impact as far as view, or?
Your impact, yeah, view, your
Again, all of that was to be done before we moved there, so I didn't, since I've moved there, I've known no different.
And for clarity, the proposed building is no further east than the existing pilings are.
There was, in the variance, and they say closer to the road?
That's where the pilings are.
No,
They're already there.
But the variance he's asking for is closer to the road than that, the way I understand it. 6'7" off the road.
And that's where the pilings are,
Those pilings are further than 6'7" off the road.
off the lot line, not the roadway.
The variance in 2005 allowed a 5-foot setback from the front. They're asking for a 6.9 now, so it's almost 2 feet further back.
It's 2 feet. Okay,
Further back, not closer.
thank you.
All right. Thank you for your time.
No, you want one shot. Next, anybody else?
10 foot wider than it is.
Right.
Good morning. Todd Garino, 397 North Carolina Avenue, and I am here representing Ovis. And
Ovis is who?
Ovis is the Ozona
Yeah, I know,
Village
but-
Improvement Society, basically a neighborhood organization that takes matters like this up. And what's brought up earlier, technically, we do not oppose the structure being built. We just do oppose the variances that are being asked for. The main one that was brought up earlier is for the safety. It is a very popular area that people do go to 7 nights a week, walking, biking, golf carts, and it does get dark. There are no streetlights there. So we were opposing based on safety issue alone. especially the front setback to the street. Obviously, the side setback has visual impairments for the rest of the community. But in terms of what we really did oppose is the street setback in terms of there are no sidewalks. Everybody is walking, and it is a real corner there. When it's dark, people come around that corner so fast that having a building that much closer to the street, I think, would be a problem.
Isn't there a fence there now?
There's a fence on the property of this
Didn't
marina.
I saw
Not in
a
front of the
photo,
pillars.
and there was a white picket fence running along the same line as the pilings. So, I mean, the available width of space is dictated already by that fence that
I would
exists.
assume all that's gonna go away because they're gonna be pulling cars in and out. And right now, there's no car traffic per se at that location. So you're gonna have cars in and out, especially if it's a bed and breakfast. It's not a
It's
long-term
not gonna be
thing.
less walking space, is what I'm saying.
I need to ask a question, and I'm looking here at this schematic. The piling, the Stonehenge pole, whatever we're calling it, that's like the farthest point out, and it's not going closer to the road, is it?
No.
Than what was proposed to be built there.
And there's a fence there now.
So, I mean, all this, it's getting closer to the street. If you look at the Stonehenge poles, it doesn't appear like this is much further than.
There you go.
I mean, it might be,
It's not any closer.
no, it's no closer. I don't, you know. So it's going farther away in part of it, and it's staying the same in part. It might, I'm not an architect. I'm not a contractor. Am I right?
Yeah, remarkably you are.
Okay, all right. So when you say things are getting closer, and there's, I mean,
Yeah,
it's,
that's how it was explained to us, is that the setback was going to move closer to the street.
and this is why when you hear about hearsay and somebody said, you know, because you just said, well, that's how it was explained to us. I mean, but I'm not an architect. I'm not a surveyor, but I'm looking at it, which everybody had an opportunity to. It's nothing's getting closer to anybody that's traveling on that road, or
That's correct.
you know. So I think it's disingenuous to come up here and say this is, you know, more dangerous to the foot traffic, because obviously you're
Well, it
not
is gonna
walking on this
increase
gentleman's
It
property.
is going to increase the traffic overall, for sure,
Well,
with people
it-
coming in and out,
It may, I don't dispute that, but,
You're talking 2 units.
yeah, we're a few people. I mean, they're not building a Hilton, I don't think.
Two cars.
I mean, come on.
Yeah, so, okay, so I'm sorry, I didn't mean to interrupt you, but I just want to make sure
Yeah,
we
no,
were
that
speaking
was-
about the same
that was the
thing,
only concern
and
was
that
the
I
safety.
wasn't misunderstanding what you were speaking about, so, okay.
Thank you.
Thank you. Anybody else wishing to speak against this?
Good
Hello.
morning. My name is Chris Fergali. I live at 222 Driftwood Drive South in Palm Harbor. I've been a resident of Palm Harbor since 1980, back when those houses were $90,000 apiece on that waterway.
Should have bought them all.
I'm just going to speak a little bit about an experience that I had in my neighborhood where some local houses were turned into Airbnb. And all of a sudden,
This isn't an Airbnb.
I know, but it's you still have people coming in from out of town. We love people. I'm in the restaurant business, so we love people to come to Florida. We love Florida. We want them to come here and spend money and enjoy themselves. When they're in a neighborhood next to your house, they're here and they're partying. It's loud, and there's no one monitoring this kind of stuff. It became such a problem in our neighborhood that there were so many complaints that police were there all the time, that these people ended up having to sell their houses and turn them back into residential. So from that experience, I just want to let you know, I can see what's going to happen here with that. Like I said, you've got the Blue Moon Motel there, you've got a hotel on Dunedin Causeway, you've got another hotel being built there. If you had a commercial place next to your house, I don't think you would be happy about it. So, just speaking in that about that, I just wanted to bring that up.
Yeah.
And that's
I I'm just gonna, there's a difference between Airbnb and a bed and breakfast. When you said there's nobody there, it's just gonna, there will be somebody there apparently in a traditional bed and breakfast. An Airbnb, you just hand somebody the keys and hope that your house is still standing at the end of the rental. But a traditional a bed and breakfast, there's somebody on site, there's somebody somewhat managing that process. So I think you'll have I don't know, there's a chance you'd have less chaos going on when there's somebody on site then.
Well, ask yourself, do you want a commercial next to your house?
Yeah, I'm
don't
not
think
disagreeing with
anybody
that
here
part of
does.
it, you know, but I just think comparing an Airbnb to a traditional bed and breakfast is not a fair comparison.
The issue of whether or not it can be there or not is easy.
Yeah.
It's
The
it's
people that are
allowed
gonna
there.
run- The people
It's
that are
an
gonna run
allowed
that are
use.
not gonna be there all night long.
Yeah, but,
They're not gonna
excuse
be
me,
there when they're outside drinking and
What
smoking.
we're saying is this is an allowed use. There's nothing, we're not
We're not
talking about
changing the
that.
zoning.
We're only talking about
Yeah.
variances here.
Yeah.
Yeah.
It's an allowed use.
Yeah.
And
Nothing
just
we can do
to
about
further
that.
Mr. Gephardt's statement, it is a requirement of the code that an owner or manager shall reside on the premises of each bed and breakfast. That's verbatim in our code.
So there will be somebody there watching it and overseeing it,
Okay,
or they're supposed to be, at least.
Thank you.
all right.
Thank you. Anyone else wishing to speak in objection? Seeing none? Anybody online? I don't believe there's anybody online for this.
No, we have no one online.
Okay. Then we'll bring the applicant back up for a rebuttal.
Good morning. Again, Jamie Mayer for the record, representing the applicant. I have a few points I would like to address in rebuttal. One, with respect to the question of notice, notice was provided to the residents on the 16th, and I know Ovis met last week on the 28th and discussed this and just made a formal decision to oppose it. So, you know, we don't, and we had to prepare when we were all working from home as well last week, and it was stressful. But I do just want to point out a few things. I would say this is not an expansion of rights. I think that's clear. A duplex structure is permitted, so it's not that rights are being expanded. The applicant lives here too. And to all the points that were discussed, the applicant has to live here also in order for this to work. The applicant has a vested interest in also having a quiet, peaceful community. There are a lot of Airbnbs which are permitted only on private residential property, but that's not what's going on here. I'm sure they're already all over Ozona. Mr. Gagg, the neighbor to the north, bought the property, his property, when a duplex structure was already permitted here. The applicant, Mr. Bennett, signed off on the variance that he requested and was in support of it for Mr. Gagg's own home. And so also where it's being proposed, again, this is the only private property that Ovis considers to be a public realm. And for that reason doesn't want the applicant to be able to build anything here. That's what you've heard. I think the board is aware that that is not competent substantial evidence, and it also doesn't consider the rights that the applicant has. It is correct that they are walking on the applicant's property. They said they like to gather there with their bicycles and their children, and the applicant has never stopped them from doing that, and that's actually not going to change because that's not the area that the duplex is going in. But I just would like to make that point that much of what you heard is distress over the fact that something they consider to be their public space will change a little bit. I would consider also highlighting, we did have a legal disagreement previously as to whether this was even something we had to go through. Instead of taking it to a different tribunal, we're here asking for this variance, and we request your support. And the DBPR, the Department of Business and Professional Regulation, regulates bed and breakfast. That's something else we'll have to go through and make sure we're in line with. I don't have anything else to say unless there are specific questions for me. But I think this is a self-evident case of a need for a variance, and I would respectfully request your all's approval. Thank you.
Questions? You got a question?
Yeah, I do, Mr. Mayor. And there's also what I observed. I took a ride up here on Labor Day, and there's very adequate parking across the street as well that's owned by the applicant. Am I correct?
That's correct. Yes.
And one other thing I noticed too, where Bayshore curves, it's further north in this property. It's more near Mr. Gagg's property. Is that not where the road curves?
That's correct, and he actually that's his white picket fence. It looks like it's about 6 feet high, pretty close to the right of way. It looks, or not a picket fence, but there is, as you can see in this photo, a white fence there. That is his property if you come down.
And I did see folks walking up and down, just in front of here, and they did walk on the shell, area. So, this is regarding safety concerns. I think there's adequate room for people still to walk if this structure did go up. And the views were pretty much obscured from ground level by the pillars that are in there now. And,
That's correct.
So that's all I really have to say on it.
Okay.
Further
Thank you.
questions?
Thank you.
Okay, with that, we will close the public hearing and open this up for board discussion. Any discussion?
Yeah, I feel like the fact that there was a permit for a structure similar in nature, and due to what happened during the economic situation from '07 to about 2014, precluded a lot of things from happening, from building, from acquiring financing and things like that, that there's a reasonableness to delay that, and then to be able to resolve that within another 2 years to build a significant thing. I think, to me, that plays a major factor in how my thought process is in this, and that it seems like it's not going closer to the road. And although I sympathize with every neighbor of the changes that happen in their neighborhood, I think that's significant. I live near a church that we're afraid it's going to sell the condos, and every day I'm like, I hope it doesn't, you know? But I know that if it does, I can't stop it, you know, because there's certain rights that landowners have. And so I don't think this is egregious based on the fact that for 13 years, 16 years, there's been some indication that something was happening there from the Stonehenge pillars, you know, that I don't think people, like Mr. Baumstein said, like those were going to hold some structure at some time, you know, so.
Anyone else?
I certainly sympathize with the neighbors. I understand what you're saying. But unfortunately, we have to go by what the substantial evidence has been shown, and unfortunately, there hasn't really been. It's mostly opinions. I get it, but that's what we have to judge each case by. So that's really all I have to say about that.
And also what I believe bolsters the applicant's case here is that he's a longtime resident, number one, and he did try to go through many steps to continue this until the steps ran out. So he's right there on the property as well, too, and I think that says a lot for this application.
Yeah, we keep hearing from neighbors, well, the closest neighbor to all this is the applicant.
Yeah.
He's not an absentee owner that's living in another state, you know, impacting a neighborhood.
Mr. Baumstein?
I don't really have anything to add. The applicant is not proposing anything that is any more impacting than what would have been built had he built the duplex when this was originally approved. He's not asking for any closer encroachment than would have been. The entitlement is there. Like everyone else, I understand the neighbors' concerns. They have a view right now that isn't going to be there, but I think they've known for a long time that view someday was going to go away. That's all. That's all I have.
With that, would like to make a motion?
I'll move for conditional approval in accordance with the findings of fact that and staff's recommendation, and in accordance to the evidence that was presented by the applicant today, and given the fact that the entitlements were pre-existing, and that the zoning is appropriate for the use.
I'd just like to say that I appreciate the neighbors coming out and speaking out and fighting for your neighborhood, but I don't think this is an extremely egregious thing that this person's asking for, you know, so I just want to say I appreciate you guys coming out and taking the time out of your day, and caring about your neighborhood. I think that's super important, you know, but we have to do kind of what we're kind of allowed to do and steered to do, and, you know, based on what we've heard and the finding of fact, so.
Is that a second?
I'll second it, yes.
I have a motion, I have a second, all in favor?
Aye.
Opposed? Unanimous. Thank you.
John
All right,
voted aye.
moving along. Next issue.
Minutes.
Yeah, well, we have another issue to discuss. We can do the minutes too, though, while we're doing it. We have a motion on the minutes?
Wasn't here.
I wasn't either.
I'll move to approve the minutes.
Second.
Got a motion, second, all in favor?
Aye.
Opposed? No.
So the question was raised at the previous meeting as to whether or not we had to continue with, as the board had to continue with allowing the online participation and how that came down. So I've looked through minutes of meetings. I've called county administration. I've, representatives in various offices. From what I can tell from the record, that was a initiative taken by this board by motion and vote. Therefore, it can be rescinded in the same manner. So if you wish to rescind that activity and no longer have online participants at meetings, that's your call.
Well, I'm of the belief that if it's important to you, then you should show up. You know, like if an applicant wants us to decide the fate of their property, then they should be willing to show up and, come here. I just feel like that's a reasonable request to expect somebody who wants us to take time out of our day and show up, for them to come here and show up to, for us to hear their case.
Okay. Then we have some members of this board that,
Can we have a board member not come and an applicant have to? I mean, is that?
Kind of discriminatory.
I know, I'm just asking the question, because I certainly don't want to,
I think when you start
Disenfranchise
getting into having applicants virtual but this side of the dais is one thing as far as having a member attend virtually, is that the audio quality is pretty good and we can pipe them in individually pretty well, and their video, their image is there. You make a motion to allow them to participate virtually as we did today. I don't know that, I think you're setting yourself up for some liability if
I agree.
you give the applicant more discretion than the public as far as attendance. So I think it's either yay or nay for both sides of the argument.
I agree.
There are, like other boards on the county, is anybody else still using Zoom, or is it's pretty much gone?
Do we LPA? I don't.
LPA uses it. Of course, the Board of County Commissioners use it.
They use it?
The Board of Commissioners does.
both ways.
Yes.
We don't, my observation, we don't have that many individuals that participate.
And here's the issue.
Okay.
And if you don't mind, I'm totally for this. Even if it means that, John has some travel plans, but he still makes by far the majority of the meetings. I'm worried about the case that's going to come, where there's going to be 50, 60, 70, 100 people who want to get online and are going to speak. We've had a few of those cases that we can remember where we've literally had to
We had to have
have
another
people
room.
downstairs.
Right.
And this, I'm worried about
The T-shirt people.
what it can happen. Other boards other county, city boards and so on that I'm aware of have done away with it completely. I support doing away with it completely. And just, again, you're right. We even had an applicant a couple of weeks ago not show up.
We had an applicant
Applicant today.
The
Second case.
Yeah.
Yeah, we had this
Childcare-
second time today.
childcare.
This is the second time that's happened, and I'm with Mr. Gephardt here
Okay. Well,
that, but that's my opinion.
A lawyer.
That's just me, so.
At PSTA, we
Need to participate.
we allow it at PSTA, and
No, we couldn't
some of
hear
the
very well.
Will County
Something was going on.
Commissioners use it.
I understand, but,
And that's a board of 15.
yeah, I agree.
Yeah,
We don't have a lot of difficulty with it.
Well, we are allowed to take a vote on it, so.
It's really been pretty minimal. We haven't had a lot of online participation. I don't think if we did away with it, that we would be depriving a lot of people of
No.
participating.
Okay. Somebody make a
You know how I'll vote, so.
Chris, do you want to make a motion?
Sure, I'll make a motion that we require physical attendance.
Do I have a second? John, do you want to say anything? You're on here.
Mr. Virtual?
Is John still there?
But you guys are doing fine. Just keep it up.
Did John I mean,
John, I'm not anti-John on my thoughts here, this isn't,
Well, we also have a alternate now too.
yeah, we do have an alternate. He thought he was going to be here today, but he just, oh, would you want to, well, let us finish this and come up.
Yeah, well,
Somebody move.
I have a motion. Do I have a second?
because I think he's dressed kind of casual.
That we didn't know.
We could have got him a jacket.
Yeah, looks like,
He's here.
looks like he's in honor of Jimmy Buffett.
Have a maitre d' that has jackets.
Let's make a second.
I know.
Is there a second?
Okay, I made a motion.
Second.
We have a motion. We have a second. All in favor?
Aye.
Aye.
Opposed?
All right, no more Zoom.
No,
Yeah. Would you please come forward up here, all right? Well, sorry, we didn't know you were here. You could have joined us.
Wait, what was the vote?
Yeah, what was the vote?
No, it wasn't. I voted
Huh?
against.
He said
Oh,
no, John
I'm
said
sorry.
no, I think.
Change the vote was,
4-2?
who was it?
Alan
Who was
did
it?
too.
Who else?
Oh, John did.
John vote against it?
Yeah.
I voted against it.
Oh.
Oh, okay.
Well, sure, you're virtual.
4-2. Okay. And your name is?
Robert Warner, Bob Warner. I'm your new alternate.
Aye.
And I just came to observe today.
Great.
How'd we do?
Welcome, Bob.
Yeah, welcome.
Yeah.
I remember when I first started, and then like a week later, I was the chairman.
I remember.
Like-
Alan remembers that too.
And for a year, I was literally like a ventriloquist doll with
Yeah,
Alan,
with Alan.
talking for me. So.
And he still has.
I've been on enough
Yeah.
boards, I've realized that usually happens.
Still has
too.
the record. Okay. Well, thank you. Good, good. Then Renee will notify you,
I need you in November.
You need me in November?
Yeah.
well, so, and then I don't know when Renee will,
When's our October meeting? I'm not going to be here in October, I think.
so,
I'm not here.
When's the November meeting? Yeah, no, we'll be out.
so we need you October, you're going to be needed October, November.
I'm here for,
Yep.
at your service.
Yep.
Go
well, thank
get a jacket and show up. You know?
you.
I wasn't quite sure how formal this
Well,
was. I'm from Connecticut,
I'll
so
let you know that.
almost anything
we're
goes.
October moves us into jacket season.
Yeah.
What moves you into jacket season?
Right. Well, the rest of us are
We
there.
wear jackets all year round.
Who notifies the alternate that they are going to be needed? Is that a clerk's responsibility?
Renee.
Renee.
Okay.
Is that as soon as you find out one person says they're not going to be here, you?
Okay.
Perfect.
They're included in our discussions, so as you let us know you're not going to be there, generally that's a part of that discussion.
Well, you probably should more formalize that more and direct to Mr. Warner directly, so-and-so's not going to be here, we're going to need you for this meeting, so that, yeah.
That works for me.
I think you've just heard we need October and November.
And I'll send you an email. May I say something too? That, Mr. McAteer sent us a copy in our an email that when we respond to emails from Renee, that we need to just send separately. Well, again, because the point was brought up that sunshine laws.
Well, what can happen, so it can, what I've seen in the past and where I've had, you learn things the hard way in life sometimes. I've seen members of previous boards, this is the fourth one of these kind of boards, not fifth now, I think the LPA, that I've advised. And I have seen things cascade where it starts out as an innocent scheduling thing, and then somebody just completely inadvertently throws in a reply all, into the reply all, and then you've got a filed hearing. And you've got, and I realize there's plenty of experienced members on this board who've been doing this a long time, but weird stuff can happen, and it's just, a reply all is just one of those things that just makes my muscles tighten when I see it. It's just one of those tough things.
We noticed.
So, yeah, so, but that was the point I'm trying to prevent, because sunshine law violations don't adhere to the county. The county doesn't, so it's the individual members who are liable for the civil, and I wouldn't think it would ever be the case in this board, but criminal penalties that apply. And you have to defend yourself with your own lawyer. It's not the county's violation, it's your personal violation. And so that's something important to remember. We're just trying to give you a heads up. Now, that hasn't occurred here, but that's part of the reason why it's such a concern.
Okay,
Okay.
Duly noted.
that's it. Motion adjourned.
Did we do the minutes?
Mr. Adjourn.
Yeah, we did.
We did the minutes.
Did the minutes.
I got a motion, I got a second to adjourn. Meeting is
Nice job, gang.
concluded.
Good job, Joe.
Thank you, Joe.
How you feel?
I feel great that I could got the keyboard. Yes, sir.